Welcome to our second lecture on criminal litigation. The theme of this lecture is jurisdiction and venue of courts of criminal jurisdiction. This lesson has 5 parts. On this slide, as you can see on the screen, is a high-level overview of the 5 parts. These include jurisdiction over a criminal proceeding, types of jurisdiction, venue of a criminal proceeding, venue and jurisdiction compared, and finally, courts with criminal jurisdiction. Let's jump right in by considering jurisdiction over a criminal proceeding. Jurisdiction over a criminal proceeding. Jurisdiction refers to the extent or range of judicial authority with respect to matters such as the capacity of the parties, the constitution of the court, the geographic area over which its authority extends, the kind or quantum of relief sought, the parties, the subject matters over which it can preside, or a combination of any of the factors listed above. Jurisdiction is pivotal to answering the following questions: which court can try the matter? Which court can try the accused? In Nigerian v. Edwards and another, it's a 1991 case, the Supreme Court distinguished between jurisdiction of a court and the power of a court when it held, whereas jurisdiction is the right in the court to hear and determine the dispute between the parties, the power in the court is the authority to make certain orders and decisions with respect to the matter before it. That's the end of our topic, jurisdiction over a criminal proceeding. Our next topic is types of jurisdiction. As we alluded to in slide 2, this part of the course has 12 subdivisions. Let's run down through the 12 subdivisions. They include original general criminal jurisdiction, original special criminal jurisdiction, appellate criminal jurisdiction, worldwide criminal jurisdiction, subject matter jurisdiction, offender jurisdiction, territorial jurisdiction, concurrent jurisdiction, exclusive jurisdiction, coordinate jurisdiction, jurisdiction as a matter of procedural law, jurisdiction as a matter of substantive law. So what is original general criminal jurisdiction? This is the power of a court to hear and determine a criminal matter and to pass judgment in criminal proceedings at first instance. This is the power of a court to hear and determine a criminal matter and to pass judgment in criminal proceedings that are not specifically reserved for courts of original, special, criminal jurisdiction at first instance. This is the power of a court to hear and determine a criminal matter and to pass judgment in criminal proceedings involving parties without discrimination or limitation and over a wide range of subject matters. The courts that exercise original general criminal jurisdiction include magistrate courts in the north and in the south, high courts in the north and in the south. So what is original special criminal jurisdiction? This is the power of a court to hear and determine a criminal matter and to pass judgment in criminal proceedings involving a particular class of individuals at first instance. This is the power of a court to hear and determine a criminal matter and to pass judgment in criminal proceedings involving a particular class of criminal omissions or commissions, actual or suspected at first instance. This is the power of a court to hear and determine a criminal matter and to pass judgment in criminal proceedings involving a controlled list of potential parties and or over a limited or specific range of subject matters. The courts that exercise original special criminal jurisdiction include area and Sharia courts in the north, customary courts in the south, the Federal High Court when trying criminal matters, juvenile courts which tries young persons, family courts when trying young persons, court-martials which tries members of the forces, that is, those who are subject to military law, coroner's court which conducts inquests into the causes of death, as well as other tribunals. What is appellate criminal jurisdiction? This is the power of a court to hear and determine a criminal matter and to pass judgment in criminal proceedings on appeal. This is the power of a court to hear and determine a criminal matter and to pass judgment in criminal proceedings following or after the determination by either a court with original general criminal jurisdiction or a court with original special criminal jurisdiction, or both. This is the power of a court and or the extent of the power of a court to review a trial court's proceedings for error. The courts that exercise appellate criminal jurisdiction include high courts in the north, high courts in the south, high court of the Federal Capital Territory, the Court of Appeal, and the Supreme Court. What is worldwide criminal jurisdiction? This is the power and or extent of the power of the International Criminal Court over individuals to hear, determine, and also pass judgments in criminal matters such as the crime of genocide, war crimes, crimes against humanity, the crime of aggression. Of course, as respects territory, its jurisdiction is unlimited, but as respects the subject matter, its jurisdiction is limited. In a later slide, we'll be discussing territorial jurisdiction. So what is subject matter jurisdiction? The power or right of a court derived from the country's constitution or any other legislation to sit over a specified subject or issue. What is offender jurisdiction? It is also known as impersonal jurisdiction or jurisdiction over a person or personal jurisdiction. Whichever expressions you use, basically, offender jurisdiction refers to the power or right of a court to try a person or an entity as a defendant. Territorial jurisdiction. What is territorial jurisdiction? It is the geographic area over which a court has the power to adjudicate. What is concurrent jurisdiction? The simultaneous power or right of a minimum of two courts to adjudicate over an offender, a subject matter, or a territory. What is exclusive jurisdiction? It is the power or rights of a particular court to adjudicate over an offender, a subject matter, or a class of subject matters, or a territory, to the exclusion of all other courts. By virtue of Section 254, subsection C, subsection 1, subsection 1, of the Constitution 3rd Alteration Amendment Act 2010, the jurisdiction of the National Industrial Court of Nigeria is exclusive to it and cannot be concurrently exercised or shared with the Federal High Court, the State High Court, and the High Court of the Federal Capital Territory. What is coordinate jurisdiction? It is a simultaneous power or right of more than one court to adjudicate over an offender or class of offenders, a subject matter or class of subject matters, or a territory. The Federal High Court, the State High Court, and the High Court of the FCT has coordinate jurisdiction over a lot of matters. And what do we mean by jurisdiction as a matter of procedural law? We are not going to define this, but this is a statutory expression that was found in the case of Ndayopo versus Dantoro. It's a 2004 case in which one of the Supreme Court justices made it clear that jurisdiction as a matter of procedural law can be waived by the litigant. Well, what do we mean by jurisdiction as a matter of substantive law? Well, one of the Supreme Court justices by name Edozie in Ndayopo versus Dantoro, is a 2004 case, made it clear that in respect of this subject matter, jurisdiction as a matter of substantive law, that no litigant can confer jurisdiction on the court where the Constitution or a statute or any provision of the common law says that the court shall have no jurisdiction. It's important to have this at the back of our minds as we consider any case that the subject of jurisdiction comes up. And it comes up in all cases actually, because the law is built on the foundation of jurisdiction. This brings us to the end of our consideration of the types of jurisdiction and the beginning of our consideration of venue of a criminal proceeding. And that's part 3 of lesson 2. So when we say venue of a criminal proceeding, what do we mean? Basically, quite simply, it is the physical location of the courthouse in which the case is tried. To illustrate, the venue of the International Criminal Court is The Hague in the Netherlands, although it can sit anywhere else. And if it does, then that becomes the venue. Well, this is a very short topic, and so that is the end of this part of the lesson. So now we are now in part 3, in which we are going to compare and contrast venue and jurisdiction. While venue relates to the location or administrative division of a court, jurisdiction relates to the extent and limits of the power of a court over a particular matter or matters, and over a particular accused or accused persons. That brings us to the end of this particular part of the course. In the next slide, we'll be starting a new subtopic or part, and that is courts with criminal jurisdiction. That's the fifth part of the second lesson. This part of the lecture has three subdivisions, such as the Supreme Court, the Court of Appeal, the Federal High Court, the High Court of the State, High Court of the FCT, National Industrial Court, Magistrate Court, Sharia and Area Court, Customary Court, Court Martial, Juvenile Court, and Family Courts, Coroner's Court, and the International Criminal Court. For each of these 13 courts, we will be considering first, how the courts were established, second, their composition and constitution, third, the appointment of magistrates, judges, or justices, that is the heads of those courts and members of the adjudicating panel where there is more than one head, by whatever nomenclature that they may be called. Let's take the first court on our list, the Supreme Court. Our first port of call will be the legal basis for the establishment of the Supreme Court, and that is contained in Section 230, subsection 1 of the 1999 Constitution of the Federal Republic of Nigeria, as amended. Our next port of call is the composition and constitution of the Supreme Court. It is pertinent to note that there is a very subtle difference between the words consists and constitutes with respect to the judicial officers we will be considering as we review the various courts. Section 230, subsection 2 of the 1999 Constitution of the Federal Republic of Nigeria as amended says of its composition, the Chief Justice and such number of justices not exceeding 21. It would seem then that composition has to do with the total number of justices permitted by the Constitution. Section 234 of the 1999 Constitution of the Federal Republic of Nigeria as amended tells us about the Constitution, and it provides that the Supreme Court is duly constituted by 5 justices of that court ordinarily. It also tells us that it is duly constituted by 7 justices of that court, that is the full court, if 1. Hearing appeals with respect to the interpretation of the Constitution, 2. Hearing appeals on whether any of the provisions relating to fundamental human rights has been, is being, or is likely to be contravened, and 3. If it is exercising its original jurisdiction. It would seem then that constitution has to do with the formation of the Supreme Court. For want of a better expression, to give it legal or constitutional flavor to adjudicate a matter or matters. Our next point of call is appointment. When studying these aspects of the operations of the Supreme Court, one needs to know the minimum qualifications to be considered a justice of the Supreme Court in the first place, as well as the steps that the executive or appointing power must follow for the appointment to be in line with the law. For the Supreme Court, the minimum qualifications are contained in Section 231, subsection 3 of the 1999 Constitution of the Federal Republic as amended. While the procedures for appointment are contained in Section 231, subsection 2 of the 1999 Constitution of the Federal Republic of Nigeria as amended. So, the Chief Justice of Nigeria is appointed by the President on the recommendation of the National Judicial Commission, subject to the confirmation of the Senate. That's found in section 231 subsection 1. Other justices of the Supreme Court are appointed by the President on the recommendation of the National Judicial Commission, subject to the confirmation of the Senate. Please, you can cross-check that at section 231 subsection 2. To be appointed Chief Justice of Nigeria or a Justice of the Supreme Court, the individual must fulfill the following conditions. First, be a lawyer, and 2, 15 years post-call minimum. That brings us to the end of our consideration of the Supreme Court. The second court on our list is the Court of Appeal. It was established by section 237 subsection 1 of the 1999 Constitution of the Federal Republic of Nigeria as amended. For its composition and constitution, we have to refer to section 237 subsection 2 and section 247 subsection 1 respectively. So what do those sections say about composition and constitution respectively? First, the composition. It is composed of the President of the Court of Appeal plus a number of other justices not less than 49, provided that not less than 3 shall be learned in Islamic personal law and not less than 3 shall be learned in customary law. Now, onto the constitution of that court. It is duly constituted by 3 justices of that court, if exercising its original jurisdiction and if exercising its appellate jurisdiction. It is duly constituted by not less than 3 justices of that court, learned in Islamic personal law, if exercising its appellate jurisdiction in reviewing a decision of the Sharia Court of Appeal. Please refer to section 239 subsection 2. Well, that relates to its civil jurisdiction, not criminal anyway. It is duly constituted by not less than 3 justices of that court, learned in customary law, if exercising its appellate jurisdiction in reviewing a decision of the Customary Court of Appeal. Please refer to section 247 subsection 1. But then again, this has to do with civil jurisdiction, not criminal jurisdiction. And now let's move on to appointment. As respects appointment, there is a distinction between the legal provisions for the President of this court and the other justices of this court, which does not exist at the Supreme Court. Well, let's consider that distinction. The President of the Court of Appeal is appointed by the President on the recommendations of the National Judicial Commission, subject to the confirmation of the Senate. Other justices of the Court of Appeal are appointed by the President on the recommendation of the National Judicial Commission. However, their appointment is not subject to the Senate's confirmation. As respects the minimum standards to be met for consideration or to be appointed as the Justice of the Court of Appeal, the individual must be 1. A lawyer, 2. 12 years post-call minimum. Please refer to section 238 subsection 1 for provisions on the President of the Court of Appeal and section 238 subsection 2 for the other justices of the Court of Appeal. That brings us to the end of our consideration of the Court of Appeal. The third court on our list is the Federal High Court. It was established by Section 249 of the 1999 Constitution. For its composition, let's refer to Section 249, subsection 2 of the 1999 Constitution as amended, which tells us that it is composed of a chief judge plus such number of judges as the National Assembly prescribes in its enabling act from time to time. For its constitution, we must refer to Section 253, which tells us that it is duly constituted by at least one judge of that court. Let's move on to appointment. The Chief Judge is appointed by the President on the recommendation of the National Judicial Commission, subject to confirmation of the Senate. Please refer to Section 250, subsection 1 and 2. The other judges are appointed by the President on the recommendation of the National Judicial Commission. However, their appointment is not subject to the Senate's confirmation. Please refer to Section 250, subsection 2 of the Constitution. As respects the minimum standard to be met for constitutional appointment, the individual must be a lawyer and must have at least 10 years post-call minimum to be suitable to be appointed as a chief judge or other judge of this court. That brings us to the end of our consideration of the Federal High Court. The fourth court on our list is the High Court of a State. It was established by Section 270, subsection 1 of the Constitution, as well as the High Court laws of the various states. For its composition, we must refer to Section 270, subsection 2 and Section 273 for its constitution. Now let's take those one by one. For the composition, a chief judge plus such number of judges as the State House of Assembly may prescribe in its enabling law from time to time. And how about its constitution? In the South, it is duly constituted by at least one judge of that court if it is exercising its original jurisdiction or it is exercising its appellate jurisdiction. Please refer to Section 273. In the North, it is duly constituted by at least one judge if it is exercising its original jurisdiction, but it is duly constituted by at least two judges if exercising its appellate jurisdiction. Let's take its appointment. As respects appointment, the position of the State High Court is the same as the position of the Court of Appeal and the Federal High Court. However, the distinction is that instead of the President, we have the Governor, and instead of the National Assembly, we have the State House of Assembly. And that is why the Constitution tells us that the Chief Judge is appointed by the Governor on the recommendation of the National Judicial Commission, subject to the confirmation of the State House of Assembly. The other judges are appointed by the Governor on the recommendation of the National Judicial Commission. However, their appointment is not subject to the State House of Assembly's confirmation. Now, what are the minimum conditions to be appointed or considered for appointment as a judge? 1. Be a lawyer and at least 10 years post-call minimum. You can refer to section 271 for provisions on that. That brings us to the end of our consideration of the High Court of a state. Our next port of call is the High Court of the FCT. For its establishment, the High Court of the FCT is the fifth court we'll be considering. The High Court of the FCT is almost indistinguishable from a state High Court, except that the FCT is not really a state, it's a quasi-state. It was established by section 255 subsection 1. For its composition, we must refer to section 249 subsection 2, and for its constitution, section 258. So let's take the first one, its composition. A chief judge plus such number of judges as the National Assembly prescribes in its enabling acts from time to time. And then its constitution, it is duly constituted by at least one judge of that court, and it is duly constituted by at least one judge if it is exercising its original jurisdiction, refer to section 258. It is duly constituted by at least two judges if it is exercising its appellate jurisdiction. Let's go on to appointment. The position in respect of appointments at the High Court of the FCT is the same as at the Court of Appeal and the Federal High Court. The Chief Judge is appointed by the President on the recommendation of the National Judicial Commission, subject to the confirmation of the Senate. The other judges are appointed by the President on the recommendation of the National Judicial Commission. However, the appointment is not subject to the Senate's confirmation. And as respects the minimum standards to be considered for appointment, the individual must be a lawyer with 10 years post-call minimum. That brings us to the end of our consideration of the High Court of the FCT. The sixth court on our list is the National Industrial Court. Let's trace the history behind its establishment. On the screen, you can see that we have the Trade Disputes Act of 1976, which was formerly a decree. Next, we have the Trade Disputes Amendment Act of 1992, also formerly a decree. And currently, we have the Section 254A, subsection A, subsection 1 of the 1999 Constitution, and Section 1, subsection 1 of the National Industrial Court Act of 2006. The screen shows the legislation that led to the establishment of the court from the earliest to the most current. However, understanding the history behind this court is essential to properly answering any questions relating to this court, and more importantly, appreciating the unique role this court plays. Let us begin by considering the jurisdiction of the National Industrial Court before the coming into force of the National Industrial Court Act of 2006. Then, sections 14, 15, 16, 17, 18, and 20 of the Trade Disputes Act vested power on the Minister of Labor and Productivity or any aggrieved party to refer labor disputes to the National Industrial Court, either for outright adjudication or for the interpretation of an arbitral award. Section 7 and 8 of the Trade Union Act provided that where the Registrar of Trade cancels the registration of a trade union, which registration is in existence on the date specified in the notice of cancellation, any official or member of the trade union may within 30 days thereof appeal to the appropriate court to make appropriate order on the purported cancellation. And Section 54 of the Trade Union Act defines appropriate court to mean the Industrial Arbitration Panel or the National Industrial Court, as the case may be. But after the coming into force of the National Industrial Court Act of 2006 and the Section 254, subsection C, subsection 1 of the Constitution, Third Alteration Amendment Act of 2010, Section 7 of the National Industrial Court Act conferred on the National Industrial Court exclusive jurisdiction to adjudicate civil cases and matters relating to labor, industrial, trade union, industrial relations, environment and conditions of work, health, safety, welfare of labor, and matters incidental thereto, among others. If you take a look at Section 254, subsection C, subsection 1, you will see that it also covers criminal matters. Now that we are done with that very brief history of that court, let us take a look at its composition and constitution. Originally, it had a president of that court and 4 other members, with the president of the court and 2 members constituting a forum. But currently, according to Section 254, subsection A, subsection 2, it provides for the composition when it says that the President of the National Industrial Court plus such number of judges as the National Assembly prescribes in its enabling acts from time to time. While Section 2, subsection B of the National Industrial Court Act of 2006, that's the enabling acts, puts that number at 12. Another relevant provision in construing the composition is the fact that according to the National Industrial Court Act of 2006, the National Industrial Court of Nigeria is composed of a president and not less than 12 judges, provided that 1/3 of the judges appointed are compliant with Section 2, subsection 4, subsection B of the National Industrial Court Act, which holds that to qualify as a judge, one must be a graduate with 10 years post-qualification, and secondly, someone that has considerable knowledge and experience in the law and practice of industrial relations and employment conditions in Nigeria. Now, let's move on to its constitution, the constitution of that court. According to Section 254, subsection E, subsection 1, it provides for the Constitution and it makes clear that the National Industrial Court of Nigeria is duly constituted by a single judge ordinarily, or it may be constituted by 3 judges if the President of the National Industrial Court of Nigeria so decides. You can refer to 254E1. It is also duly constituted by a single judge in the exercise of its criminal jurisdiction, and for that 254E2. Now let's treat appointments of judges of the National Industrial Court. The President of the National Industrial Court is appointed by the President on the recommendation of the National Judicial Commission, subject to the confirmation of the Senate. 254B1. Other judges of the National Industrial Court are appointed by the President on the recommendation of the National Judicial Commission. 254B2. To be appointed, the President of the National Industrial Court or a judge of the National Industrial Court, the person must fulfill the following conditions: be a lawyer, 10 years post-call minimum, have considerable knowledge and experience in the law and practice of industrial relations and employment conditions in Nigeria. That brings us to the end of our consideration of the National Industrial Court. The seventh court on our list is the Magistrate Court. For its establishment, we must refer to the respective magistrate court laws of each state. For its composition and constitution, we must do exactly the same thing. And for its appointment, we must do exactly the same thing. But let's take Lagos State as representative of the others, because it's a common exam issue. According to Section 4, subsection 1 of the Magistrate Courts Law of Lagos State, the appointment of magistrate is done by the Lagos State Judicial Service Commission and not the governor. As a general rule, the minimum requirements are usually 1. Be a lawyer, and 2. 5 years post-call with relevant experience in some states, and 2 years post-call in other states. And that brings us to the end of our consideration of the Magistrate Court. The eighth court on our list is the Sharia or Area Courts. Well, for their establishment, you must turn to the respective laws in operation in the respective states. Same thing has to be done for its composition and constitution, and same thing has to be done for their appointments. The ninth court on our list is Customary Court. For establishments, composition, constitution, and appointment, we have to be guided by the respective laws that are operative in the states that have customary courts. They are not uniform, and so there's no point going through the laws of 36 different states at the same time. The 10th court on our list is the military courts, also known as court-martial. For their establishment, you must refer to Section 129A of the Armed Forces Act for General Court-Martials, Section 129B of the Armed Forces Act for Special Court-Martials. But see also Section 130 subsection 1 and Section 130 subsection 2 for additional provisions on general court-martials, as well as Section 130 subsection 3 of the Armed Forces Act for Special Court-Martial additional provisions. The implication of this is that two kinds of court-martials exist. For their composition and constitution, for general court-martials, refer to Section 129A, 131, and 132. For special court-martials, 129B and 130 sub 3. As for when the court-martial is duly constituted, please refer to Section 133 of the Armed Forces Act. And take note that the convener of the court-martial cannot be its president or member. That is contained in Section 134, subsection 1. The commanding officer of the accused and the officer who inquired into the subject matter constituting the charge against the accused cannot be a member of the court-martial or a judge advocate. Please refer to Section 134, subsection 2. And when a court-martial may be dissolved is contained in Section 136. As respects appointments, there are several provisions, including for the minimum qualifications for an officer to be appointed a member of the court-martial, please see Section 133, subsection 2 of the Armed Forces Act. For the minimum qualifications to be appointed the President of a court-martial, please see Section 133, subsection 3 of the Armed Forces Act. How appointment of members other than the President may be carried out is contained in Section 133, subsection 4. Appointment of a judge advocate is contained in Sections 133, subsection 5 and 6. If a court-martial is held at a location without officers meeting the minimum qualifications stipulated by this Act, who may be appointed and how is covered by Section 133, subsection 7. The provisions governing the appointment of a captain or an officer of corresponding rank as President of the court-martial due to the unavailability of a major or an officer of corresponding rank is contained in Section 134, subsection 3, and the provisions governing the appointment of an alternate president due to the death of the former or due to his inability to attend the court-martial is covered by Section 136, subsection 4 of the Armed Forces Act. So there are a total of 8 provisions to consider with respect to appointments and court-martials. That brings us to the end of our consideration of court-martials. Our next court is the juvenile court, stroke the family court. This is the 11th court. It was established courtesy of the Children and Young Persons Ordinance of 1943 originally, and courtesy of several amendments is now known as the Children and Young Persons Act. The Act was first passed into law in 1943 by the British colonial government. It held sway over all parts of the Protectorate of Nigeria on the order of the Governor-in-Council. It was also enacted into law in Lagos in 1946 and made to apply to the eastern and western regions of Nigeria later that year. The northern region caught up with the rest of the country in 1958. Nowadays, nearly every state has a Children and Young Persons Law, also known as CYPL. Also relevant to this discussion is the Child's Rights Act. Section 149 of the Child's Rights Act of 2003 establishes the family courts for each state of the Federation and the FCT. Section 154 of the Child's Rights Act provides for the creation of a family court at 2 levels, that is, the court as a division of the High Court at the High Court level, and the court as a division of the Magistrate Court at the Magistrate level. A couple of states have passed the Child's Rights Act, at least 25 as at our last count. These days it seems that the juvenile courts are not allowed anymore by the ordinary courts to exercise jurisdiction over all children who are accused of criminal offenses, except those children who are charged jointly with adults and children who are charged with homicide, who may be tried as adults in the ordinary courts. As for their composition and constitution, it depends on the provisions of the respective state laws, and as respects the appointment, it also depends on the provision of the respective state laws. This overview of the Family Court and the Child's Rights Act was brought to you courtesy of a publication of Professor Isabella Okagboe in an article entitled Children in Conflict with the Law, the Nigerian Experience. In the credits section, you will find further details about this reference we considered in preparing this part of the lecture. The 12th court on our list is the Coroner's Court. Let's take a look at its establishment. And this is brought to you courtesy of Wikipedia. The first ever legislation in Nigeria on the power to conduct or order an inquest into the manner or cause of death and to investigate or confirm the identity of an unknown person who has been found dead within the coroner's jurisdiction was the Coroner's Ordinance of 1944, which stipulated that only sudden deaths involving non-natives, that is, the white colonists, were to be reported to the native authority for autopsy in the northern region. Then there was also the Coroner's Law, Cap 131 of 1954, Laws of the Federation of Nigeria and Lagos, which permitted magistrates to conduct inquests under the said law. And that is why today in Nigeria, every magistrate also doubles as a coroner. Thereafter, we have the Coroner's Act of 1958, which extended the mandatory reporting of sudden deaths to everyone in Nigeria, be the person a native or a non-native. The most recent Coroner's Law of Lagos State is the Lagos State Coroner System Law of 2007, which is commonly cited as the Coroner's Law 2007. According to Part 2, Section 4 of the Coroner's Law 2007, the coroner can hold inquest on suspicious death that comes to his or her knowledge if the cause of death is abnormal, such as violence, sudden death, death in psychiatric hospital. The coroner can even exhume a dead body so as to conduct a proper determination of the cause of death. Section 9 of the Coroner's Law 2007 gives the coroner the power to postpone a cremation or even postpone a burial, while Section 10 of the Coroner's Law gives everyone the task in relation to dead bodies in the following words: when anybody is found or a person has died in such circumstances as to make the holding of an inquest under this law necessary or desirable, it shall be the duty of any person finding the body or becoming aware of the death forthwith to inform the nearest police officer, and upon receiving any such information, such police officer shall notify the coroner having jurisdiction to hold an inquest. Section 15 of the Coroner's Law 2007 provides that an inquest shall hold whenever a coroner is informed that the death of a deceased person within the coroner's district was as a result of death in a violent, unnatural, or suspicious situation. That's a brief background. As for its composition and constitution, it is as provided in the respective state laws establishing the same. As regards the appointments, it is as contained in the respective state laws. That brings us to the end of our consideration of Coroner's Court. The 13th and final court on our list is the International Criminal Court. It was established by a multilateral treaty called the Rome Statutes of the International Criminal Court. This treaty was prepared 11th of July 1998. It became a binding treaty on 11th of April 2002, while the court came into being on the 1st of July 2002. That binding multilateral treaty is known as the Rome Statutes of the International Criminal Court, and Article 1 of that statute established the International Criminal Court. Onto its composition and constitution. The General Division consists of the 18 judges of the court. Please refer to Article 36, subsection 1. The judiciary of the court is composed of 3 divisions: the pre-trial division, the trial division, and the appeals division. That's in Article 34b. The pre-trial chamber, the trial chamber, and the appeals chamber are the arms of the International Criminal Court that carry out the judicial functions of the court. That's in Article 39, subsection 2. The trial and pre-trial chambers consist of 3 judges each from their respective divisions. That's in Article 39 subsection 1 and Article 39 2b2. Both the trial and the pretrial chambers have not less than 6 judges. The appeals chamber consists of all 5 judges of the appeals division. It actually consists of the president and 4 other judges. Please refer to Article 39(1) and 39 2b1, 2bi. In addition, many of the functions of the pretrial chamber may be carried out by a single judge sitting as his own chamber. Article 39 2b3. The presiding judge of a chamber is elected by the judges of the chamber in question. The appeals chamber decides on a presiding judge for each appeal. The pretrial chamber plays an important role in the first phase of judicial proceedings and makes the decision whether to confirm the charges against the potential accused. After charges are confirmed, the trial chamber determines the innocence or guilt of the accused, imposes a sentence on a convicted person, and may order a convicted person to pay money for compensation, restitution, or rehabilitation for victims. If either the prosecutor or the convicted person appeals the decision of the trial chamber, the appeals chamber may decide to reverse or amend the decision or sentence or order a new trial before a different chamber. Please refer to the credit section for sources. As respects appointments, the judges are elected to the court by the Assembly of State Parties, see Article 36A. They serve 9-year terms and are not generally eligible for re-election, Article 36(9)A. All judges must be nationals of state parties to the multilateral treaty, Article 36 sub 4, and no 2 judges may be nationals of the same state, Article 36 sub 7. Judges must be persons of high moral character, impartiality, and integrity who possess the qualifications required in their respective states for appointment to the highest judicial offices. Article 36(3)A. They must also possess criminal law and procedural competency. That's Article 36(3)B1. They must also possess international law competencies in international humanitarian law and the law of human rights. Article 36(3)B2. They must also possess language proficiency in the working languages of the court. Article 36(3)C. That brings us to the end of our consideration of courts of criminal jurisdiction and also the end of lecture 2 as well. So in this section we list all the sources, whether they are statutes, cases, or publications that were consulted in the preparation of this lecture. There are 5 sources on this slide. Another 5 sources on this slide. Another 5 sources on this slide. Another 5 sources on this. Another 5 sources on the slide, mostly journals and articles. Another 5 sources on this slide. Another 5 sources on this. Another 5 sources on this. And that brings us to the end of our lesson, jurisdiction and venue of courts of criminal jurisdiction. Thank you for your time and attention.